Hello students, good day and welcome back to our classes 121 Introduction to Philippine Criminal Justice System, and this is Miss Malaya going to teach. Okay, for this day we are going to have a discussion about the second pillar, which is the prosecution. First now, um, what are the three main functions of prosecution? Okay, first is to conduct preliminary investigation. We also have the second one, which is to conduct inquest proceeding. And of course, we have the third one, which is act as a lawyer in the criminal prosecution. We also have here some national or the National Prosecution Services or the NPS. So our NPS, no, this is the prosecution service here in the Philippines. This is under the Department of Justice. So they are going to conduct their preliminary investigations and prosecuting criminal cases in the name of the Filipino people. Kaya tinatawag po yan siya na people of the Philippines versus a specific name na mga accused po natin. So the next one we have here, of course, this is headed by a prosecutor general. So this was appointed by the president, no, and oversees the entire agency. And the prosecution staff are lawyer personnel. So ibig sabihin lahat po ng kasamahan natin sa National Prosecution Service or people who are in prosecution, they are lawyers. Hindi po tayo pwede maging kasamahan or maging miyembro po ng prosecution unless otherwise we are lawyers. So again, no, they are conducting preliminary investigations or trials before the first level courts. We also have here, they are assigned with regional, provincial, and city prosecution offices. No, they are located nationwide. So, prosecutors handle cases within their respective jurisdictions. Kasi po, by jurisdiction po, again, yung ating um, pagpa-file in the prosecutor's office. We also have here, prosecutors have the authority to conduct preliminary investigations for crimes and file criminal cases. Again po, si prosecutor siya po yung nag-balance out, naghahanap po ng probable cause during the preliminary investigations if meron ba tayong probable cause so that the prosecutor will file a criminal case in court if meron po tayong probable cause. Okay, against the accused. So, tinimbang po natin yung mga evidences na kinuha natin. Then we find out na meron po talagang probable cause kaya pwede tayong makapag-file sa court. Again, ang magpa-file ng criminal case, si prosecution po or si prosecutor. So, the entire prosecutorial machinery of the government falls under the control of the National Prosecution Services under the Republic Act number 10071. So again, this is aligned with the DOJ mission with the speedy and fair administration of justice in the Philippines. Now, public prosecutor, sino ba si public prosecutor? So, this is the person, no, that is assigned under the Department of Justice and National Prosecution Service. So, si public prosecutor po, siya po yung prosecutor natin sa municipal, regional offices or prosecution offices po natin. They are salaried public attorneys and they are required to handle prosecution of all criminal cases. They are also handling cases no in an official government duty. So government worker po si public prosecutor. While si private prosecutor po, sino naman siya? He or she is still a lawyer but they are hired to prosecute cases that are private with a private complainant and they are paid with legal fees or compensation by a client or by their client. They are private contractual attorney client relationship. And participation in prosecution is not compulsory. Kapag kanid lang po ng private prosecutor ng isang kliyente. So, nag-hire sila na ombudsman as a special prosecutor. Now, so, as ombudsman, meron siyang special role which is to be a special prosecutor That is directly to prosecute no, selected cases concerning public sector corruption, malfeasance within its jurisdiction, instead of having to refer them to other prosecution arms. And of course, no, this concentration of investigation and prosecution powers in the office aims to enhance its effectiveness in combating graft and corruption. Now, PAO or the Public Attorney's Office, so independent autonomous office attached to again the DOJ or Department of Justice. So this is headed by a public attorney or dati chief public attorney yung kanyang tawag. So they are providing free legal assistance and representation to indigent persons in criminal, civil, labor, administrative, and other cases. Yung mga wala pong pambayad na magkaroon po ng private attorney, binibigay po yan ni PAO. Institution of criminal action. So, this is the filing of criminal complaint or information in court and initiating prosecution for an offense. So, para po magkaroon po tayo, if there is a crime in the law enforcement, in the first pillar, ngayon meron ng krimen. Anong gagawin natin? Magfa-file tayo ng it's either complaint or information para po makapag-initiate po tayo ng prosecution for an offense. And it can be filed directly in court or after a preliminary investigation. And after the case is filed in a court by prosecutor, proceedings move to arraignment and trial stage. Okay, ano po ba yung complaint? Okay, yung complaint po, yan po yung sworn statement na ginawa po ni victim. It's either si witness then or a law enforcement officer that a crime has been committed. So this will initiate the criminal process but it does not directly lead to charges. Yan po yung complaint. Nag-complain lang po tayo. For example, yung victim files a police report alleging theft, no? That is a complaint, no? Nagreklamo lang po tayo, nag-file tayo ng complaint sa police station. While as for information, this is a formal accusation filed by a prosecutor charging a defendant with a specific crime. Ngayon, ang nag-file na po talaga is si prosecutor doon sa court with a specific crime. Nandoon na yung title ng crime, sino ba yung accused natin, and there is a probable cause. Now, requirement for information is probable cause and often follows a complaint or grand jury indictment. For example, nag-file po si prosecutor ng information charging a suspect with grand theft based on the police report and evidences. So, yun po yung ating kaibahan ni complaint at saka ni information. So now let's have in again institution of criminal action. What is the effect or what are the effects? Interrupts the period of prescription of the offense. Marks the official commencement of criminal prosecution in court. Ano ba yung prescription of crimes? Ibig sabihin ng prescription of crimes in the Philippines, no? That is the period after which the government can no longer prosecute someone for a crime. And this is enshrined in Article 90 of the Revised Penal Code of and Act number 3326. So these are the prescription periods of the following crimes, no? For example, death, reclusion perpetua or reclusion temporal. The prescription period for that is 20 years. So after 20 years, hindi ka na pwedeng file ng case with that with the crimes na may punishable na ganito na mga period kasi nga kebale na expire na siya or we also have other afflictive penalties, so 15 years, correctional penalties, 10 years, except arresto mayor, which is 5 years, light penalties, 1 year, offenses of oral defamation and slander by deed, no, 6 months lang yan. So, after 6 months, hindi ka na pwedeng mag-file kasi prescription period, na-expire na po yung ginawa. Libel or similar offenses, that's 1 year. Okay, so yan po yung prescription of crimes. Now, who must prosecute criminal action? Sino ba dapat? Okay, kung sino ba dapat ang mag-prosecute ng mga na-file or ipa-file ng mga criminal actions, that is si public prosecutors as well as, again, private prosecutors as we have mentioned earlier. Pag sinabi natin private prosecutors, may be authorized if a public prosecutor has heavy workload, lack of public prosecutor. Kapag wala na po tayong makita na ibang public prosecutor na available kasi marami na siyang tinatrabaho, pwede tayong mag-hire ni private prosecutor. Under pa rin yan siya, no, na in supervision ni public prosecutor. So, we have prosecution of private offenses pa rin, no? These are some of the cases, adultery and concubinage as private offenses. So, for this matter, This means that the only offended spouse can initiate criminal prosecution. Ibig sabihin po, ang pwede lang pong mag-file ng case or mag-file ng reklamo po is only the offended spouse. Okay? So, siya lang po ang makapagreklamo. So, the reason for this one, no, we also have the law enforcement and prosecutors cannot act on their own. So, hindi po pwede na si law enforcement or si police officer ang magpa-file ng complaint. Kasi po, ang magpa-file po is, again, the offended spouse. So, the reason for this, no, is the belief that these offenses primarily affect the marriage and the family. So, naapektuhan po yung pamilya at saka marriage, and the decision to prosecute should lie within the offended spouse. So, sino yung, what are the requirements for this one? So, prosecution, again, si offended spouse, siya yung mapafile ng complaint sa prosecutor's office. Yung complaint natin must allege specific acts of adultery or concubinage and provide evidence, no, to support their accusations. And yung ating offended spouse cannot include both parties. Ibig sabihin po, yung isa lang, they must choose to accuse either the adulterous spouse or the paramour or yung kabit. Consent, pardon, or condonation by the offended spouse can bar prosecution kasi pinatawad mo yung asawa mo or pinatawad mo yung kanyang kabit. What are some of the important points of for this matter? The offended spouse may withdraw the complaint at any time, even after charges have been filed. No, reconciliation between spouses can lead to the dismissal of the case. The offended spouse is now expected now to actively participate in prosecution. They can appear in court and present evidence, and of course, the conviction for adultery or concubinage carries potential penalties, including imprisonment and fine. So again, no, in adultery and concubinage as private offenses, si offended spouse lang yung pwedeng mag-file ng complaint doon sa prosecution. For this one, again, no, uh, we also have here who can charge. Okay, only in adultery, specifically adultery, no, only married woman can be charged with adultery along with her male partner who knew she was married. Okay. And for concubinage, only the married man can be charged with concubinage along with his partner if they live together openly or have scandalous sexual relations. So, you try to familiarize the keyword for this one, no? So, again, yun po yung ating mga proof na kailangan natin. Okay? Now, let's proceed to this one. Does a minor have a right to initiate the prosecution of an offense? Pwede ba daw na si minor, when you say minor, wala pang age of emancipation, that is 17 years old. Okay? Wala pa siyang 18 years old kasi age of emancipation natin is 18 years old, di ba? That's legal age in the Philippine setting. Now, in the Philippines, generally, no, the minor or a minor generally does not have the right to directly initiate the prosecution of an offense on their own, including crimes like seduction, abduction, and acts of lasciviousness. However, there are some exceptions to consider. Again po, general rule, wala po tayong minor na pwede pong makapag-initiate ng prosecution sa isang offense. But there are still exceptions to consider for this matter. So, what are these? Okay. General Rule Article 344 of the Revised Penal Code states that offenses like seduction, abduction, and the acts of lasciviousness can only be prosecuted upon a complaint filed by the offended party or their parents, grandparents, or guardian. Okay? Since minors are considered unable to act on their own due to their age and lack of legal capacity, they don't have the authority to file a formal complaint and initiate prosecution themselves. Okay? So, yun po yung mga general rule natin. So, sabi dito, unable to act on their own. Lagi daw yung mga minor. Okay? So, exceptions. Ito yung exceptions natin. Age of discernment. Kapag sinabi natin age of discernment, if the minor is deemed to have sufficient age of discernment, no? Meaning, they are They can understand the nature and consequences of their actions, no? They might be allowed to participate in the prosecution process, no, with of course the assistance of their legal guardian. This is determined on a case-to-case basis po, no? And the next one is the assistance of legal guardian. For this matter, regardless of the age, a minor can always involve their parents, their grandparents, or guardian to file a complaint, no, on their behalf. So these responsible adults then become the complainants and handle the legal proceedings. And of course, we have the third one, of the exception, no? Government intervention. So for government intervention naman po, if the minor is orphaned, okay, or their legal guardians are unwilling or unable to pursue the case, no, the state, no, yung ating government through the Department of Justice, no, in the Philippines or other designated agencies, they can step in and initiate the prosecution to protect the minor's rights and to ensure, of course, justice. So these are the exceptions, okay, for the law. So, special protection of children against abuse, exploitation, and discrimination Act, that is RA 7610, who can file a complaint under the said Republic Act, no, of sections 27. We have the offended party. For the offended party, this includes, no, the child who was abused, was exploited, or discriminated against. We also have the parents or guardians, no? This includes the biological parents, the adoptive parents, and legal guardians, and ascendants or collateral relatives within the third degree of consanguinity. For this one, this includes, no, um, within the grandparents, the aunts, uncles, and cousins. So, pwede yan siya. We also have here officer, social worker, or representative of a licensed child caring institution. This includes our individuals working with the NGO or the national government organizations, orphanage, and other organizations dedicated to child welfare. We also have here officer or social worker of the DSWD. This includes, no, the personals coming from our, of course, DSWD na mga workers. We also have the barangay chairman, okay? For this one, yung barangay chairman natin, the head of the smallest government unit, no, in the Philippines. And lastly, we have at least three concerned responsible citizens where the violation occurred. No? This allows community now to intervene when they witness child abuse. So yan po yung mga pwedeng mag-file ng complaint, no, under RA 7610 of Section 27. We have here, of course, Section 10, Rule 110 of the Revised Rules of Criminal Procedure. So, a complaint or information is considered sufficient if it clearly and distinctly states the following. Of course, the name of the accused. This includes now the aliases, yung mga angga, nicknames if known. We also have designation of offense. For this one, you cite the specific law that was violated and its corresponding article and section. Acts or omissions complained of, describe, no, the acts or omissions constituting the offense in detail. This includes the time, the place, and of course the manner of commission. The name of the offended party, this includes their alias or nickname, if known, if kilala, and their relationship to the accused if meron or if it is necessary. And we have here approximate date of the commission of the offense. We also have here the approximate date and of the time commission of the offense. No, again, no, the specific date or a close time frame. So again, no, at all or about approximate na kasi hindi tayo sure of if anong oras talaga na-commit yung offense. And lastly, place where the offense was committed, of course, no, for this matter, no, specify the specific location or the jurisdiction of saan nangyari yung offense or yung crime. Now, still, no, we have here Section 10, Rule 110 of the Revised Rules of Criminal Procedure. When an offense is committed by more than one person, all perpetrators should be named in the complaint or information. So, ibig sabihin po, i-include po natin lahat ng mga perpetrators ng gumawa ng crime. We also have here, under Section 13, Rule 110 of the Revised Rules of Criminal Procedure, a complaint or information must charge but one offense, except only in those cases in which existing laws prescribe a single punishment for various offenses. Section 14 of Rule 110 of the Revised Rules of Criminal Procedure, before the plea, okay, amendments are flexible both in form and in substance. When we say amendment, no, a complaint or an information can be amended in form or in substance without leave of court, or hindi mo na kailangan na mananghid sa court, no? Or sabihin, at any time before the accused enters his plea. This means you can make changes to correct errors, clarify details, or even add new charges before the accused formally responds to the allegations. And after the plea, okay, amendments are more restricted, requiring leave of court or, again, court approval for formal changes. So, we also have here substitution. Always require leave of court approval and typically starts a new process. Okay. We also have here, consider the impact of the accused rights when amending or substituting. So, yun po yung mga dapat natin na i-remember, no, sa Section 14 of Rule 110. Under Section 15 of Rule 110 in the Revised Rules of Criminal Procedure, we have the general rule. Under Section 15, Paragraph A, the action shall be instituted and tried in the court of the municipality or territory where the offense was committed. Again, kung saan po na-commit yung offense or where any of its essential ingredients occurred. This means the court closest to the location where the crime happened or where a crucial element took place has jurisdiction. Note, continuing offense. An offense is one that continues over time. So, theft, no, is not a continuing offense. So, the venue would be where the taking of the property happened, kung saan po nangyari yung pagkawat. Estafa, file where the misappropriation took place, kung saan na kinumit yung estafa, saang lugar. So, crime committed in the Philippine territories, they are filed in the RTC, no? And crime committed by public officers, they are filed by, or they have the jurisdiction of Sandigan Bayan, no? Specifically with a salary grade of 27 and above. So, a salary grade of 27, probably nasa 131,000 yan to 146,000 po, no? And above. Okay, so yan po yan siya. So, let's proceed now to preliminary investigation. Okay. So, under prosecution, again, no, kakandak sila ng preliminary investigation. Okay, we have here Section 1, Rule 112 of the Revised Rules of Criminal Procedure. So, this gives the authority duties of the police officers in conducting a preliminary investigation. So, this is an inquiry or procedure, no, that's conducted by the police to determine if there is probable cause to believe that a crime has been committed and that a particular person committed it. Now, let's define probable cause under a AM number 05-826-SC. So, when we say probable cause, no, this is the reasonable ground to believe that the person has committed a crime. So, it is not more than a mere suspicion but less than an absolute certainty. So, what are some of the cases on probable cause? So for this one, AM number 05-826-SC, this is known as the device guidelines for the conduct of preliminary investigation. For this one, this provides the specific guidelines for police officers in determining probable cause. Okay, So we have here a landmark case, no, De Chavez versus OMB 513 SCRA 6382 2007. So this case, no, established two-pronged. We say pronged. This is divided into two parts. The first part is that an officer or ang arresting for officer has personal knowledge to which refers to his or her own sensory perception of the crime. Ibig sabihin, five senses. The second prong or the second part is that reliable information from a credible source, which refers to information received from another person about the crime. So, yun po yung sinabi ng first natin na landmark case. Now, for the second landmark case, we have here Lydell L. Conquilla versus Judge Lauro G. Bernardo, Municipal Trial Court, Pukawi, Bulacan, February 9, 2011. So, Judge Lauro G. Bernardo conducted a preliminary investigation when he did not have the authority. Okay. Issued a warrant of arrest that was void and he reduced the bail without properly having jurisdiction over the case. And because of that matter, MTC judges, no, are no longer authorized to conduct preliminary investigation because they are not of authority po. Okay, so you must remember that one. Now, when is preliminary investigation required? This is Section 1, Rule 112. Okay, we have here with a penalty of at least 4 years, 2 months, and 1 day. Regardless of the fine, except as noted in exceptions no below. These are the following listed in Section 6 of Rule 112, such as what are these following crimes na hindi pwede? Crimes against national security, public order, revenue or property, environmental laws, certain election offenses, and more. So, yan po yung required natin except the following under Section 6 of Rule 112. Now, when is preliminary investigation not required, even if the offense requires preliminary investigation? So these are the following sections. Section 7 of Rule 112, Section 17, Paragraph C of Rule 114, Section 7 of Rule 112, Section 3F of Rule 112. Now, under Section 7 of Rule 112, when a person is arrested lawfully without warrant, walang warrant, involving an offense which requires preliminary investigation, inaresto, walang warrant, tapos yung offense kailangan ng preliminary investigation, the penalty is at least 4 years, 2 months, and 1 day dapat. And an information or complaint may be filed without need of preliminary investigation. And if there is an inquest officer in the place where he got arrested, an inquest shall be conducted. And of course, no, if there is no inquest officer, complaint or information shall be filed properly to the court on the basis of affidavit of the offended party and of the arresting officer. Okay. Under this one, if a person lawfully arrested without a warrant does not absolutely bar him from availing preliminary investigation. So, kahit na inaresto ka nang wala kang warrant of arrest, pwede ka pa rin mag-request ng preliminary investigation. He may ask for a preliminary investigation. Before granting preliminary investigation, magsasign muna siya ng waiver under the provision of Article 125 of the Revised Penal Code, which is the delay in the delivery of detained persons to proper judicial authorities. This is no essentially no aims to prevent arbitrary retention and protect the constitutional rights of due process. So, who does it apply to? So, syempre, public officers or employees who detain any person for legal reasons. No? Ano ba yung tinatawag natin dyan? So, failing to deliver the detained person to proper judicial authorities within the prescribed period of how many hours? We have the 12, the 18, and 36 hours. For 12 hours, crimes punishable by light penalties. For example, theft, disobedience. For 18 hours, for crimes punishable by correctional penalties, for example, reckless imprudence, resulting to damage. We also have slander for 36 hours for crimes punishable by afflictive or capital punishments, for example, murder. We also have rape. So, yun po yung waiver na isa-sign niya. Okay? We also have here A waiver should be in provision of RA 7438 shall be in writing, signed by person arrested, detained, or under the custodial investigation in presence of his counsel. Otherwise, it shall be void. So, remember that matter, no? It's very important, no? RA 7438 is an act defining certain rights of persons arrested, detained, or under custodial investigation. So, dapat po, no, magwi-waiver muna. That is in provision of Article 125 as well as in Article or Republic Act 7438. So under Section 17C, Paragraph C of Rule 114 of the Revised Rules of Criminal Procedure, under the waiver of Article 125, no, again, no, does not bar a person arrested from applying bail while in preliminary investigation is pending. Pwede po tayo makapagpiyansa or bail. So, preliminary investigation shall be terminated within 15 days from its inception. And this can allow someone detained but not yet formally accused to seek bail before charges are filed. So, pwede po tayo makapagpiyansa kahit na wala pa pong charges na na-file sa atin. Under Section 7 of Rule 112 of the Revised Rules of Criminal Procedure, okay, if complaint or information has been filed without preliminary investigation, the accused who desires a preliminary investigation within 5 days from the time he learns of its filing, he can ask for a preliminary investigation. Under Section 3, Paragraph F of Rule 112 of the Revised Rules of Criminal Procedure, within 10 days after investigation, investigating officer shall determine whether or not there is sufficient ground now to hold the respondent for a trial. Okay, now let's proceed to inquest. Okay, when we say inquest, no, when is an inquest proceeding conducted. So, a person is arrested without a warrant. Mag-i-inquest tayo. And probable cause to believe the person committed the offense. So, when is an inquest proceeding conducted? So, ginagawa po natin ng inquest, no? Again, no? If the person is arrested without a warrant and there is a probable cause, no? Do not forget that one. So, when is the commencement of inquest, no? Sisimula po yung ating inquest if the arresting officer informs the inquest officer about the arrest. So, the inquest no officer must conduct the inquest within 24 hours of being informed. Ngayon, kailan naman ma-terminate yung ating inquest, no? The inquest officer issues a resolution. So, i-release na yung tao if insufficient yung mga evidences na wala tayong nakita na probable cause. Pwede tayong mag-file ng complaint for preliminary investigation if there is a probable cause that existed. Now, sino ba yung magkakandak ng ating inquest? Of course, that is the inquest officer, no? This is a prosecutor designated by the city or the municipal prosecutor, and they are responsible for conducting the inquest and issuing the resolution. Now we have some initial duty of inquest officer under Section 5 of Rule 113. First is assertion. Ano yung mga dapat gawin niya? Next is to inform and next is to conduct. So when we say assertion, this is to ascertain that the legality of arrest was correct, no? Dapat alam niya ni inquest officer. Next is to inform, no? Kailangan na-inform yung mga arrested persons natin of their rights, no? Miranda rights, no? Right to remain silent, right to counsel, right to be informed of the complaint against them. And of course, conduct. They will now take sworn statements from arresting officer, from the complainant, and the witnesses. And they need to also examine the documentary evidences. Now, when is the resolution of investigating prosecutor and review? This is under Section 4 of Rule 112. So first, if the inquest officer files a complaint, the investigating prosecutor conducts a preliminary investigation. And then, if the prosecutor will issue a resolution, they can file an information in court if sufficient evidence exists, or they can dismiss that case if evidence is insufficient. And we have here, either party can petition to the court, no, for the prosecutor's resolution. So reopening of investigation, again, pwede tayong um, magsabi, no, that an inquest proceeding cannot be reopened. So, hindi po pwede. But if there is new evidence, no, an investigating prosecutor can conduct a reinvestigation upon filing a motion and with court approval. So that is the end of the second pillar, which is the prosecution. Thank you, everyone, and have a good day.